Ever wonder how that amazing architect working on a new U.S. skyscraper came from overseas? Or how that brilliant bioengineer landed at a cutting-edge American research lab?
Yeah, it's something a lot of people are curious about.
And it often involves this, well, fascinating and actually surprisingly intricate process of U.S. companies sponsoring foreign professionals for immigration.
Exactly. We've been really digging into excerpts from the Sponsoring U.S. Employee for Immigration podcast. It really pulls back the curtain on the details, how global talent comes to work in the U.S.
Right. So think of this as your shortcut, your way to quickly grasp the crucial elements. We're aiming to cut through the immigration jargon.
Yeah, get to the really interesting, sometimes unexpected bits of how this whole system operates.
And in today's interconnected world, understanding this flow of global talent, well, it's not just informative, it's kind of becoming essential, isn't it?
Absolutely. So today we'll be focusing on the core difference between temporary visas and the ones for permanent residency. We'll look at key temporary work visas, like the much talked about H-1B for specialized jobs, and the L-1, which is for transfers within international companies.
Got it.
And then we'll also dig into the PRM labor certification, that's a big one, plus employer responsibilities, which are significant, and crucially, why good legal help is so often necessary.
Okay, let's unpack this then. It seems like the first big fork in the road is non-immigrant versus immigrant visas. What's the fundamental difference there?
Well, the key difference really just boils down to intent, length, and purpose of the stay.
Okay.
So non-immigrant visas are for a specific reason, like a specific job, and for a limited time. They let someone live and work here temporarily. They have an end date, basically.
Kind of like a work permit with an expiration date built right in.
Precisely.
Okay.
And while some can be extended, under certain rules, they don't automatically lead to a green card, to permanent residence.
Right.
Immigrant visas, on the other hand, those are for people intending to live and work in the U.S. permanently.
Okay, the green card route.
Exactly. The employment-based ones, the EB categories, that's the main path we're talking about here. And it's usually a much more involved process.
Yeah.
Often needs that labor certification we mentioned, a formal petition. So yeah, temporary intent versus permanent intent. That's the core idea.
Got it. Temporary versus permanent. Okay. Now, when we talk temporary work visas, the H-1B always seems to be in the news. What are the essentials we need to know about that one?
Right, the H-1B. It's specifically for jobs in what they call specialty occupations.
Specialty occupations. What does that mean exactly?
It means roles that demand highly specialized knowledge and the practical application of that knowledge. Usually it requires at least a bachelor's degree or sometimes higher in a specific field.
Okay, so like engineers, scientists.
Yeah, exactly. Think engineers designing new tech, scientists doing research, IT pros building software, financial analysts. Yeah. Roles like that.
So a company couldn't just use an H-1B for, say, a job that doesn't really need a degree or that kind of specialized skill.
That's right. The employer, the sponsor, has to show the job genuinely needs that specialized knowledge and the specific degree. Yeah. They also have to commit to paying the employee at least what they pay similar U.S. workers in their company, or the local prevailing wage for that job, whichever one is higher. And a really critical first step, they have to file something called a labor condition application, LCA, with the Department of Labor. And they have to do that before they can even submit the H-1B petition itself to immigration to USCIS.
Okay, so significant hoops for the employer right at the start. What about the employee side? What do they need to qualify?
Generally, the person needs a U.S. bachelor's degree or an equivalent degree from another country. Sometimes, for certain fields, a specific state license or a professional certification might work too. And interestingly, there are ways work experience, like relevant professional experience, can sometimes substitute for a degree, under specific rules, of course.
Now, I've definitely heard about the H-1B lottery. Why a lottery for a work visa? That seems odd.
Yeah, it does seem odd, but it's really about supply and demand. There's just incredibly high demand for a pretty limited number of these visas each year. Congress sets an annual cap. Right now, it's 65,000 for the general pool, plus an extra 20,000 for people with a U.S. master's degree or higher.
Okay.
But the number of applications, it often blows way past those limits. So a lottery becomes necessary just to randomly pick which petitions even get looked at.
Wow. So it's pure chance then?
To a large extent, yes. It's not just a bureaucratic step. It really forces companies to gamble on getting the talent they need. It can delay projects, impact competitiveness.
I can imagine.
Some companies even file multiple petitions for different people, just hoping one gets picked. Adds a lot of cost and hassle.
So even if a company does everything right, finds the perfect person, meets all the rules, their chance still hinges on random draw.
Pretty much.
Yeah.
Employers first do an electronic pre-registration. If that registration gets selected in the lottery, then they file the full, detailed H-1B petition. It really just highlights the intense competition for skilled foreign workers. Now, it's worth noting, universities and nonprofit research places, they're usually exempt from these caps.
Oh, okay. That's interesting.
And for duration, an initial H-1B is usually up to 3 years, extendable for another 3. So 6 years total, typically.
Right.
There are ways to extend beyond 6 years, but usually only if a green card application is well underway.
Mm-hmm.
And another key thing, H-1B portability. Someone already on an H-1B can often switch employers pretty smoothly once the new company files its own H-1B petition. Of course, that needs a new LCA first, too.
Interesting. Okay, so the H-1B seems focused on bringing in specific skilled people, often from outside the company's current global team. What if a multinational company wants to move, say, a manager or someone with unique company knowledge from an overseas office to the U.S.? That's the L-1 visa, right?
Exactly. The L-1 is tailor-made for that. It facilitates transfers within multinational companies that have a qualifying relationship. Think parent, subsidiary, affiliate, branch. As long as they're operating both internationally and in the U.S. There are two main types. L1A for managers and executives coming to a similar role here, and L1B for employees with specialized knowledge.
Specialized knowledge.
Yeah.
How is that defined? Is it like the H-1B specialty occupation?
It's different. It's knowledge that's specific to the company. Deep understanding of their unique products, services, research, equipment, techniques, management, maybe internal processes, stuff that's specific to that organization and how it operates internationally.
Got it. So L1A for leaders, L1B for people with unique internal know-how. What do the company and the employee need to show?
The employer has to prove that qualifying corporate link exists between the foreign and U.S. entities and show they're actively doing business in both places.
Right.
The employee needs to have worked continuously for the foreign part of the company for at least 1 full year within the last 3 years before applying to come to the U.S.
Okay, 1 year out of the last 3.
Yep. And they have to be coming to the U.S. to work in either that managerial executive role for L1A or in a specialized knowledge position for L1B.
And how does the L1 compare to the H-1B in terms of things like caps or wage rules?
Well, that's a key difference. Unlike the H-1B, the L1 doesn't have an annual numerical cap.
Oh, no lottery.
No lottery.
Mm-hmm.
And there's no specific prevailing wage rule from the Department of Labor like the H-1B has, although naturally they still have to pay fair wages consistent with U.S. workers and follow labor laws.
Okay.
Initial approval is usually 3 years, but only 1 year if it's to set up a brand new U.S. office.
Makes sense.
Then extensions are possible, but there are maximum stays. 7 years total for L1A managers XX and 5 years total for L1B specialized knowledge folks.
7 and 5 years max. Okay.
And here's something interesting for big companies. They can apply for something called a blanket L petition.
Blanket L.
Yeah. If the company meets certain criteria, usually large, established multinationals, they get this pre-approval. It lets them streamline transfers significantly. Eligible employees can often apply for their visa directly at a U.S. consulate abroad, just with internal company paperwork, bypassing a lot of individual petition steps with USCIS.
Wow, that blanket L really does sound like a big efficiency boost for major global players.
It definitely is.
Okay. Now, you briefly mentioned a few others earlier, O1, TN, and E3. Can you give us just a quick snapshot of those?
Sure. The O1 visa is for individuals with extraordinary ability. Think top tier in sciences, arts, education, business, athletics.
So really high achievers.
Exactly. The bar is very high. You need to show sustained national or international acclaim. Lots of proof required.
Gotcha. TN.
TN is specific to the U.S.-Mexico-Canada Agreement. USMCA used to be NAFTA. It's for qualified Canadian and Mexican citizens coming to work temporarily in certain listed professional jobs.
Yeah.
They need specific degrees or credentials for those listed jobs.
Okay, specific professions, specific nationalities, and E3.
E3 is kind of like the H-1B, but it's exclusively for nationals of Australia coming to work in specialty occupations here.
Ah, just for Australians.
Right. It has its own annual cap, though historically it hasn't always been filled. And like the H-1B, the employer needs that approved labor condition application, the LCA, first.
Okay, that clarifies the main temporary options. Now let's pivot. Let's talk about the path to staying permanently getting a green card through work. You mentioned EB1, EB2, and EB3. How do those differ?
Right. The employment-based, or EB, immigrant categories, they're basically tiered, prioritizing different levels of achievement, education, and skills. EB1 is the top tier, called priority workers.
Priority workers, okay.
It's for people really recognized at the very top of their field. There are 3 subcategories. EB1A is for that extraordinary ability, again, sciences, arts, education, business, athletics. What's really interesting here is you can self-petition.
Self-petition. You don't
Right.
need an employer.
Correct. No employer sponsor needed, and no PRM labor certification process, which we'll get to. You basically argue your own case based on your achievements.
Wow. Okay, what are the other EB ones?
The EB1B is for outstanding professors and researchers with international recognition. They do need an employer sponsor and a permanent job offer, but still, no PRM needed.
Right.
And EB1C is for multinational managers and executives. Similar criteria to the L1A visa we discussed, worked abroad for the company, coming to a high-level role here, employer-sponsored, also no PRM.
So the big advantage for EB1 is often bypassing that PRM process, making it faster.
Generally, yes.
Yeah.
That possibility of self-petitioning in EB1A is pretty unique, too, letting people drive their own green card case based purely on their accomplishments.
EB2 is for the superstars. What about EB2? Who fits there?
EB2 is for professionals holding an advanced degree that's usually a master's or higher, or a bachelor's plus 5 years of progressive work experience in the field. It also covers people with exceptional ability in sciences, arts, or business. Now, usually, EB2 requires a permanent job offer from a U.S. employer and going through that PRM labor certification process.
Usually, so there's an exception.
There is a really important one called the National Interest Waiver, or NIW.
National Interest Waiver.
This lets certain individuals self-petition or have an employer petition for them without needing the specific job offer or the PRM process.
How does that work?
They have to convincingly show that their work is in the U.S. national interest. This means proving their proposed work has substantial merit and national importance, and that they are well positioned to actually advance that work.
So it's about the impact of their work on the country.
Exactly. It's a fascinating path for people whose work could have broad benefits for the U.S. beyond just one company.
That NIW sounds like a great option for researchers or entrepreneurs, maybe.
Definitely. It offers a route based on the potential impact of what you do.
Okay. And then there's EB3. That sounded like it covers a wider group.
You're right. EB3 is broader. It has 3 subcategories. Skilled workers, needing at least 2 years of job training or experience. Professionals, needing a U.S. bachelor's degree or foreign equivalent. And then a catch-all called other workers, for unskilled jobs needing less than 2 years training. Now, for all EB3 categories, you generally need that job offer from a U.S. employer, and you absolutely need to go through the PRM labor certification.
No exceptions like the NIW here.
No NIW for EB3. And a really critical point about EB3 and sometimes EB2, depending on the country, is waiting times.
Waiting times?
Yeah, visa availability backlogs. They call it the priority date. Basically, because of annual limits per country and per category, people from high-demand countries like India or China, or those in the other workers category, can face very long waits, sometimes many years, even after their initial petition is approved, just for a visa number to become available.
Years. Wow.
Yeah.
That really highlights the global demand, doesn't it?
It absolutely does, especially for certain skill sets and from certain parts of the world.
Okay, so for most EB2 and all EB3, this PERM labor certification keeps coming up. Let's break that down. What exactly is PERM and why is it such a big deal for green cards?
Right, PRM. It stands for Program Electronic Review Management. It's run by the U.S. Department of Labor, and it's a fundamental, often lengthy first step for most employment-based green cards.
And its purpose?
Its main goal is to protect the U.S. labor market.
How so?
It's designed to ensure 2 things. First, that hiring a foreign worker for a permanent job won't negatively impact the wages or working conditions of U.S. workers in similar jobs.
Okay.
And second, crucially, that there are no qualified, willing, and available U.S. workers who meet the actual minimum requirements for the specific job being offered permanently to the foreign national.
So the government basically wants the employer to prove they couldn't find a qualified American for the job first, like really prove it.
Exactly. They have to conduct a real test of the labor market.
So what does that involve? What are the steps?
It involves several key stages. First, the employer has to very carefully define the job duties and, importantly, the absolute minimum requirements: education, experience, skills.
Minimum requirements. They can't tailor it to the person they want to hire.
No, absolutely not. That's a huge red flag for the DOL. It has to be the genuine minimum needed for anyone to do the job.
Okay, then what?
Then, the employer has to get a prevailing wage determination, a PWD, from the Department of Labor. This sets the minimum wage they must promise to pay the foreign worker once they get the green card, based on that specific job and location.
Got it. Define the job, get the wage set. What's next? Recruitment.
Yep, then comes the mandatory recruitment effort. The employer has to make a good faith effort to recruit U.S. workers.
What does that look like in practice?
It includes placing a job order with the State Workforce Agency, the SWA, for 30 days. Running 2 Sunday newspaper ads, though, for professional jobs. One can often be in a relevant professional journal instead.
Newspaper ads. Still.
Yep, still required by the regulations, surprisingly. Plus, they have to post a notice internally at the work site where the job is located.
Okay.
And if the job is considered professional, which many EB2 and EB3 jobs are, they have to do 3 additional recruitment steps from a list the DOL provides.
3 more. Like what?
Could be things like participating in job fairs, posting on the company website, using online job boards like Monster or Indeed, trade websites, campus recruitment, bunch of options.
Wow, that sounds like a really thorough search. A lot of work for the employer.
It is. And after all that recruitment activity finishes, the job isn't over.
What happens then?
Then comes maybe the most critical part. The employer has to carefully review every single resume or application they received from a U.S. worker. They have to interview anyone who looks potentially qualified.
Okay.
And they must meticulously document the lawful job-related reasons why each U.S. applicant who applied was not hired.
Lawful job-related reasons.
Yes. Like they didn't meet the minimum education requirement or lacked a specific required skill clearly listed in the ad and job description. This documentation becomes the audit file. It's absolutely crucial.
The audit file.
If, after all that, the employer concludes no qualified, willing, and available U.S. workers were found, then they can finally file the PRM application itself, the ETA Form 9089, electronically with the Department of Labor.
And filing that form is basically them saying, we did everything right, we searched hard, no qualified U.S. workers here.
Exactly. They were attesting under penalty of perjury that they complied with all the PRM rules. And this filing has to happen within a specific time window after the recruitment ends.
Okay, so the application goes to the Department of Labor. What did they do with it?
The dealer reviews it. They can basically do 3 things. Certify it, meaning, okay, you met the requirements, proceed to the next step with USCIS.
Good outcome.
Best outcome. Or they can deny it. A denial usually stops the process cold unless you appeal successfully. Might have to start PRM all over again.
Bad outcome.
Very bad. Or, and this is quite common, they can audit it.
Audit? What does that mean?
It means they formally ask the employer to send in that entire audit file, all the recruitment proof, resumes, interview notes, rejection reasons. They want to scrutinize everything.
And that causes delays?
Significant delays. An audit can add many months, sometimes even a year or more, to the process. Occasionally, they might even impose supervised recruitment, where the DOL dictates exactly how the employer has to re-advertise and re-recruit under close supervision.
Wow. It sounds like dotting every I and crossing every T is absolutely critical.
It truly is. PRM is incredibly technical. Tiny errors, wrong wording in an ad, missing a recruitment deadline by a day, defining the job requirements poorly can trigger an audit or denial.
So that audit file needs to be perfect from day one, just in case.
Absolute pristine. Even if you don't get audited initially, you need it ready. The whole PRM process itself, from starting the wage request to getting a final certification, can easily take 12 to 18 months, often longer, especially with an audit.
Oof. That really drives home how rigorous and time-consuming this key step is.
It really does.
So, given all these complexities, H-1B lotteries, L-1 rules, PRM recruitment, it's clear employers take on a lot when they sponsor someone. What are their main legal and ethical duties here?
Oh, the obligations are significant, and they run through the whole process. First, good faith is key.
Yeah.
Honesty in all dealings with the government and the employee. All information has to be accurate.
Okay.
Non-discrimination is huge, especially in perm recruitment. They have to consider all U.S. applicants fairly, regardless of origin or anything else protected.
Right.
Wage compliance is critical. Paying the required wage that prevailing or actual wage for H-1B, the offered wage meaning the PWD for perm green card.
Or keeping records.
Massive record keeping. Keeping the public access file for the H-1B LCA, that perm audit file we just talked about, and of course the standard I-9 forms verifying work authorization for everyone.
Ah.
There are notification requirements, like posting notices at the worksite about the H-1B or PRM filing. Generally, the employer has to pay most, if not all, of the government filing fees and associated legal costs for these processes.
They can't make the employee pay.
For things like H-1B and PRM, generally no. The employer bears those costs. And finally, they have a duty to notify immigration if the job ends for any reason before the visa status or green card process is complete.
Okay, lots of ongoing responsibilities. What about specific people in the company? Like, what's the role of HR managers versus, say, a company VP who signs the forms?
Good question. HR managers often act as the central coordinator. They manage timelines, communicate with the employee, with different departments, with the company's lawyers.
A logistical hub.
Exactly. They gather internal documents, monitor compliance with things like wage rules and postings, and crucially, they often support the PRM recruitment under the lawyer's guidance, placing ads, tracking applicants. They also handle onboarding and offboarding, which can have visa implications.
Okay. And the officers signing off.
Company officers or designated signatories have the ultimate legal responsibility. They're the ones signing the petitions and applications, attesting to the truthfulness of everything under penalty of perjury.
Serious stuff.
Very. They also have to demonstrate the company's financial health, especially for green cards, proving the company can actually afford to pay the offered wage permanently. And they're formally affirming that there's a real job offer and the intent to employ the person long-term under the conditions stated.
So it's a serious, legally binding commitment right from the top. What happens if a company messes up, if they don't meet these obligations?
The consequences can be pretty severe, and they vary. It could be denial of the petition or even revocation if it was already approved.
Okay.
There can be hefty financial penalties, big fines, orders to pay back wages if they underpaid. In more serious situations, especially with patterns of noncompliance or fraud, a company can be debarred.
Debarred, meaning?
Meaning banned from sponsoring any foreign workers for a period of time, sometimes permanently. And in cases of outright fraud or willful misrepresentation, there's even potential for criminal charges against the company or individuals involved.
The criminal charges?
Yes. Plus, beyond the direct legal and financial hits, there's the damage to the company's reputation. That can really hurt their ability to attract talent, both from abroad and domestically. It really underlines the huge risks if these obligations aren't taken seriously.
No kidding. Okay, listening to all of this, the intricate rules, the PRM process, the employer duties, the potential penalties, it sounds incredible.
Exactly. They know how to interpret the rules, track the constant updates and procedures, filing requirements, processing times at different government offices, which can be wildly unpredictable.
Okay.
Second, strategic planning. They work with the company to figure out the best visa strategy. Is H-1B right? L-1.
Oh.
O-1. For the green card, should we try for that national interest waiver or go the PRM route for EB-2 or EB-3? They advise on timing, potential roadblocks like quotas or backlogs.
So they map out the best path forward.
Precisely. Third, compliance. This is huge. They guide employers through all those requirements. We talked about LCA postings, PRM recruitment steps, wage rules. Record keeping, making sure everything is done correctly minimizes the risk of audits, violations, penalties.
Right. Avoiding those pitfalls.
Absolutely. They also prepare and meticulously review all the legal forms and the mountains of supporting documents, ensuring accuracy, completeness, consistency. That's crucial to avoid delays or denials just based on paperwork errors.
It sounds like they take a lot of the detailed, stressful work off the company's plate, too.
They definitely do. They act as the main contact with USCIS, the Department of Labor. They track case progress. And critically, they handle responses to requests for evidence, RFEs, or those PRM audits. Those often require detailed legal arguments and tons of documents.
Yeah, dealing with government queries.
And they're great at spotting potential problems early. Maybe the job requirements for PRM look weak. Maybe the evidence for L-1B specialized knowledge isn't strong enough. Maybe the person's country of birth means a huge green card backlog.
Yeah.
They can identify these issues up front and strategize around them.
Proactive problem solving.
Exactly. Look, there's obviously a cost to hiring good lawyers, but honestly, in the long run, it almost always saves the company time, internal resources, and huge potential headaches.
Wow, so?
By managing the process efficiently, avoiding errors that could mean refiling, facing long delays, or even losing a key employee. The cost of a denial or compliance violation usually dwarfs the legal fees. It's really an investment in getting it done right.
That makes a lot of sense.
Well, we have certainly covered a lot of ground here, haven't we, in this deep dive into sponsoring employees for U.S. immigration.
We really have.
So just to quickly recap the big takeaways, we looked at that key difference, temporary non-immigrant visas versus permanent immigrant visas, right?
Right. Temporary versus permanent intent.
We explored some key temporary types like the H-1B for specialty jobs with its lottery and the L-1 for intracompany transfers.
Uh-huh. And the different green card paths, EB1, EB2, EB3.
Exactly. And we really unpacked that PRM labor certification process, the recruitment, the audit file, why it's needed for many green cards.
And highlighted those significant responsibilities employers have, legal, ethical, financial.
Yes. And finally underscored just how crucial experienced immigration lawyers are for navigating this whole complex system successfully.
That's a great summary. Hopefully for you listening, this gives you a much clearer, maybe more insightful picture of everything involved in bringing skilled professionals to work in the U.S.
Yeah, you can really appreciate the layers, the requirements, the commitment needed from everyone involved.
Absolutely. And, thinking about all these detailed regulations and procedures, it does make you wonder, what does this complexity tell us about how much we value international talent versus the hurdles companies face trying to access it?
That's a great point. It's this fascinating tension, isn't it?
Yeah.
Between needing global expertise and navigating these intricate legal frameworks, all mixed with the hopes of talented individuals worldwide.
It really is. And, with global competition for top talent getting fiercer all the time, it really raises a big question for the future, doesn't it?
What's that?
Well, how might these U.S. immigration processes need to adapt or evolve, to better meet the needs of a really dynamic, interconnected global economy going forward?
That is definitely the million-dollar question, a crucial point to think about. If you, our listener, want to dig deeper into any specific visa or maybe that PRM process, we definitely encourage checking out official government resources like the USCIS or Department of Labor websites, or just keeping up with news on immigration policy changes.
Good advice. Well, thank you for joining us on this deep dive.